Good day, welcome back to another webinar. And today's topic, how to approach your legal matter or your family legal matter in the specific scenario. You may apply these principles to your own matter, to a different matter, for example, a motor vehicle accident, someone owing you money, or somebody suing you. Alternatively, a domestic violence matter, which is also connected to family law, or an harassment case matter, whereby the parties could be neighbors, third parties, as the case may be. Today's topic will focus generally on child custody matters. You may apply to child maintenance matters as well. I may jump between various matters so that this video can be practical and applicable to a wide range of audience. I have done some typing, and basically the topic is how to approach your family legal matter. Various points which I have outlined, points 1 to 5, and hopefully if you follow this video, you'll be able to have a bit of a sense on how to deal with your specific legal matter, considering what I have said. Okay, let's start with point number 1. Know what outcome you want. That's very important. And the outcome you want does not necessarily mean you want to win. That is maybe the first step to follow, but what is winning? What are the actual elements of the specific win? I think that's very important. For example, in a child custody matter, apologies, winning may entail, or getting what you want may entail, that you have reasonable, proper care and contact to your minor child. In this specific regard, it might entail having contact every second weekend. It may entail, in the specific battle, maybe to have half school holiday contact. It may entail having shared contact, 50-50, or a hybrid thereof, maybe 5 days, 5 days, 2 days, 2 days, and so on. You need to know exactly where are you going to, because that is how the rest of your case will be unpacked and unfolded. You cannot deal with a legal matter with the assumption that I'm going to just say what I want to say and get what I want. You need to know exactly what you want in order for the other party and the court to know exactly how to formulate the specific case. And the same applies to defending a legal matter. You need to know exactly what outcome you require. If, for argument's sake, a party applies to have contact to your minor child, and he or she would like, for argument's sake, 50-50 care and contact, shared care, half the time with the mother and half the time with the father. You cannot deal with this matter in stipulating, I want that application to be dismissed completely and the other parent can have no contact. That's how I'm going to win this matter. That won't happen. You need to be logical in your approach. You need to know that, number one, the other party may have contact, but my defense, my objection deals with the issue concerning shared care, 50-50. That's what problem I have here. And if I am going to be successful in my application, I would oppose the shared care arrangement. I'll be successful in that regard, but at the same time, the other party may have reasonable contact. For example, contact every second weekend. I cannot go to court and expect the court to kick the case out, because I do not want the other parent to have any contact at all, or I want it to be unsuccessful. Yes, there are scenarios, there are situations, many situations that may apply, whereby a court would say the other parent cannot have contact, or you will be successful in the application having it kicked out. But that's not how you should deal with a matter generally all the time. You need to have a general desired outcome in your specific case. You need to know the strengths and weaknesses in your case. You need to know what your best case scenario is, what your worst case scenario is. And by knowing that, you would know how to pitch the specific matter. The art of negotiation, basically. In a child maintenance matter, you know that your best possible bet would be to receive a child maintenance amount of, in my fictitious example, 1,000 rand per month. That would be the best case scenario. But you also know that the other party will oppose it. If you suggest 1,000 rand per month, he or she will say, no, we can only afford 500. So maybe strategically wise, prepare your documentation in the sense, I want 1,000 rand as a worst case scenario, but let me try 1,100 rand and I can justify it. Of course, you must be able to justify it. And hopefully, I will receive the 1,000. But you have an amount. You know where you're going towards, because all your calculations will be based upon that 1,000 rand or the 1,100 rand per month. The school fees, the accommodation, the creche fees for the other child, medical, food, toiletries, groceries, and so on. So that's very important to know. You need to know what you ultimately require and and later on you'll determine how you get there. But you need to know exactly what you want. It must be reasonable. Once you determine what you require, what you want, in a care and contact arrangement, in a child maintenance arrangement, you need to formulate. Point number 2, formulate what steps you need to take to get the desired outcome. Now, obviously, an attorney, an advocate, they will have their own formulas on how they will plan the matter. You as a lay person, you need to know, okay, I would like to apply for primary care over my minor child. What do I require? Number 1 is I will require some type of support for that type of request. I need to prepare information. I need to be able to convince the court that I can care for the minor child on a primary care level or a 50-50 type of arrangement. And how do I do that? I need to write out exactly how in the past I have cared for the minor child. I can attend to the minor child's emotional well-being, psychological well-being. I have a bond with the minor child. I can deal with homework, extramural activities. I'm providing information that would assist me in convincing the other party that I can care for the minor child. I would go one step further. Part of my steps would be to obtain documentary information, maybe from the schools, where they confirm that you were always involved in the minor child's life. You always come to the extramural activities. You would continuously, on a regular occasion, contact the school in finding out how the minor child is doing. If the school has any issues regarding the minor child, you will always be there. So you are obtaining information. These are part of your steps. You'd at the same time consider, before maybe going to court, maybe asking the other parent, can we maybe obtain the assistance of another professional person, a social worker, psychologist, to assist in doing an assessment as to what would be in the minor child's best interest regarding what you want. So these are the steps. These are the for the formulation of a winning plan in order to get what you want. So you have to formulate what steps you will take. Yes, the mother or the father might say, I do not want an expert on board. Or the school might, for example, say, we do not want to get involved. They shouldn't do that. But if they do that, that is fine. But you have a formula, you have a step. You know where you're going to. You are, of course, at the same time going to formulate or obtain information regarding the other parent's circumstances as well. My apologies, you should first deal with your circumstances. You are going to obtain information regarding why you can care for the minor child, your accommodation. Do you have enough space to care for the minor child to live? Does your work allow you to have contact with the minor child or care for the minor child? Do they allow you to do that in this specific scenario? Do you work from home? Can you leave home a bit earlier to collect the minor child from daycare or from school and take the minor child home with you? Or can you have facilities in place for the minor child to be at daycare after school and you collect the minor child afterwards? Can you deal with the homework of the minor child? That's very important. Do you have the facilities for that and so on? That's very important. That is regarding you. My apologies. Then we focus on the other parent. Part of your formula, part of your strategy. The other parent, what are the negatives regarding the other parent? What are the issues involved with the other parent? For example, let us deal with the issue concerning work. The other parent works all the time. The other parent would not have enough time to care for the minor child. Or the other parent lives so far away from the minor child's school. Or the area the other parent lives in is not conducive to the minor child's development because there are no daycares there. It's very far out, whatever the case may be. And these are relevant information which you have to use to create a case. Now, I'm certain if you're listening to this, to me now speaking, I am, regarding this fictitious scenario in my mind, I am now creating. I'm creating something that was not there before on paper, a strategy, pen and paper. It's very important that you do this. And by doing this, you start creating this picture, this roadmap as to how am I getting from point A to point B. Point A being I can only see my minor child every second weekend and half school holidays. Point B would be I would like to have my minor child with me half the time. And these are the reasons why it makes logical sense. Psychological, emotional, physical, financial, whatever the factors are. And you consider the other parents' circumstances as well. And ultimately you want to work this formula out that will show, or the result of this specific formula would be that the minor child should be in your care half the time, or most of the time, or whatever the case may be, or have contact, or that you can claim maintenance, or you have a case for a great amount of maintenance. You've shown that the minor child's school fees cost so much money, the groceries cost so much. You've unpacked it. You have your Excel sheets. You have your documentation. You have your supporting documentation. You have medical receipts. You have extramural receipts, whatever the case may be, petrol bills and so on. So you're formulating, you are preparing a case. So when I go to the maintenance court, I have my documentation, my evidence, my proof. Now, point number 3 is a very important point. And I think if point number 3 is not properly executed, you'll be wasting a lot of money, even if you are making use of a lawyer, because the lawyer can only elicit information from you. The lawyer cannot create data and information from the sky, from the air. He might have done 1,000 different cases, but your case is unique. The circumstances surrounding your case only applies to you and nobody else. Your minor child might have the same age, might have the same gender, might attend the same school as a client of his or hers prior. But it does not mean the circumstances are the same. Parents work different times, the minor child's needs are different, income, expenditure are all different. Therefore, you can never apply one family scenario to another family scenario. It's very rare that the facts equates or mirrors each other. It may apply, for example, if the child is just born, a newly born child, and then you could maybe apply the situation differently, whereby one couple and another couple of the past had the same circumstance, the same scenario. But generally, all cases are different, and the facts of one case does not necessarily apply to a different case. Point number 3, focus on relevance and logic and not emotion. The reason why I'm saying so is whenever I consult, or most of the time, and I'm being honest with you, most of the time, 7 out of 10, 8 out of 10 times I consult with a client regarding a care and contact matter with this acrimony between the parties, the client would spend a lot of time in the consultation. Not most all the time. I'll stop the client. I control my consultations, but a lot of the time the consultation bad mouthing the other parent, talking about a lot of negative stuff about the other parent, more than they have to. Put it that way. Just mention it once, explain to me the circumstances, but they focus on that as opposed to more relevant things. Like, for example, the mother would, for example, say the father cannot have care and contact to the minor child because 3 years ago he unfortunately swore her out and he belittled her in front of other people. She focuses solely on those points continuously in the consultation, and every time you want to come back to the issue, ma'am, but can he care for the minor child? You guys are separated now for the last 2 years. You have protection order against each other. Can he care for the child? How has he cared for the minor child in the past? We're not focusing on those specific points. We're focusing all the time on the emotional issues between the parties. And the question is, can she care for the minor child? That must be determined as well. I need to deal with that because that's part of my consultation. I need to determine whether or not, or whatever approach we take, whatever formula we devise, it needs to be a working formula, but it can only be a working formula specific to your circumstances. Can the mother care for the minor children? Can the father care for the minor children? The past is relevant, but only so much. I cannot draft 40 pages of affidavit whereby 35 pages of the affidavit deals with issues between the parties. I need to focus on the issues at hand. Therefore, I'm saying focus on relevance and logic. Deal with emotions, number one, in one paragraph, in two paragraphs, in one page. But focus on the issues of here. Can the other parent care for the minor child? Can the minor child be in the other parent's care for half the time? Can the other parent deal with schoolwork, extramural activities, the location of the other parent's residency to the school? Does the other parent have a bond with the minor child? Does the other parent have the emotional, psychological capabilities of dealing with this specific child's emotional well-being? This minor child might have a very strong attachment to the father. The minor child always lived with the father. The father minor child has a very good mental bond. Can the minor child be away from this father? Can you tear that bond apart and have the minor child now live with the mother, in the specific example, without it negatively affecting the minor child? Or would it be in the minor child's best interest to live with the mother? Those are very important things. For argument's sake, if the minor child is 17 years old in matric, for argument's sake, and finishing matric, and now the father wants to relocate to a different area, he had a prime attachment, but the minor child is in finished school properly here in Cape Town, but the father wants to go to Johannesburg. It might make sense in this specific scenario for the minor child to remain with the mother, although the minor child does not have the primary attachment with the mother. But once the minor child completes school or turns 18 years old, then the minor child can decide where to go to, with the father or remain with the mother. So these are important things to focus on. Many times, more than half the times, whenever a client comes to my office, he is history. Thank you for that. We appreciate his history, but we're focusing on the minor child. And whatever decision we take regarding the minor child has nothing to do with the history. It's relevant to a certain extent, but your relationship between the other parent is over. Spirit of relevance, yes. I'll give you an example. Whether or not the father was abusive towards you, or the mother was disrespectful towards you as a father during your relationship 3 years ago, would not affect whether or not you should pay 100 rand maintenance or 101 rand. It doesn't mean, for example, if the mother swore the father out countless times, she should get less maintenance because of that. Whatever amount of maintenance she is entitled to get for the minor child has nothing to do with the past. Same regarding care and contact matters. It does not mean that because the father was rude to the mother in the past, he will now automatically receive less care and contact to the minor child. Or if he was nice to the mother, he will now have more contact to the minor child. Or because he pays the mother more maintenance, he has more contact. He pays less maintenance, he has less contact. It doesn't work like that way. Of course, there are exceptions, and all factors have to be considered. Sometimes one factor does actually play a role. But I'm being general here, and I'm using my fictitious examples in my mind. With my fictitious cases which I'm looking at, you might apply to a different case and to your specific circumstances. And that's the beauty of using your mind and imagination. You can mold it to whatever direction you want to do. Now let's move to point number 4. Do not get sidetracked by irrelevant issues, example, past issues. I think I touched upon that as well. That's very important to do. What I have noticed is, and this is based upon the hundreds of applications or court documentation I drafted and dealt with over the last many years, could be thousands by now, is that the moment somebody says something bad about you, you go on the attack or the defensive, and then you want to attack back. And then we lose focus on point number 2 and point number 1. We lose focus on that. For example, in a care and contact application, the mother might, for example, say, I would like, part of her defense would be, the father cannot have contact to the minor child because 10 years ago he was using drugs. Okay? But it's common cause, it's well known that he stopped using drugs 10 years ago, and he's been clean since then, and he's been a wonderful father. Then the father will spend a lot of time trying to disprove that specific point, but despite that point being irrelevant, all that he should have done was to say, yes, I had a drug problem then, I have been rehabilitated for the last 10 years, and that's it. We move on to the next point. And they start focusing on those specific points. And because they're focusing on the drug issue that happened 10 years ago, in 5 pages out of our 30 pages, just try to disprove that, which is irrelevant, we're losing focus on the main issue. Can he care for the minor child? And then the question is, could we not have used 4.5 of that 5 pages on trying to explain your case stronger as to why you can care for the minor child. Come with better examples. Okay, that's point number 4. And point number 5, stick to your plan and execute it. Now this fictitious plan which we have, and if you have been following this webinar for the last 20 minutes, I'm certain you are seeing one scenario, one picture in your mind, and I'm looking at a different one in my mind. So there could be a lot of different cases happening fictitiously at the same time, but stick to your plan. Go to plan point number 1 again and say, this is what I wanted, and stick to your plan and execute it. Do not start something halfway and not proceed. For example, if you were drafting a maintenance calculator, finish drafting the maintenance calculator. Have it in front of you. Okay, and then you start working further from there. If you were approaching schools or collaterals or psychologists or whatever they are, continue with that. If your plan was to have 50-50 care in contact, continue on executing that specific plan of action and make it happen. I sometimes get exhausted with clients whereby they just want to pay the advocate, and advocate will make magic happen. Sometimes we do, but I can be honest with you, the magic will be much better should you be part of the journey with your legal team. A client should not be on the side of a legal team whereby you pay the lawyer does everything. The lawyer sends you some information, you provide it, and no, you need to be invested in your case. So in the same way, if you're making use of a lawyer, be invested in your case. And in the same way, if you're dealing with the matter on your own, be even more invested in your case, because there is no outside person to assist you in directing you or in a proper course. If you are in court, remember you get different type of magistrates and judges. Some judges will sit there and they will look and sound as they're agreeing with you. And this happens to me all the time. I'm always in court. And sometimes you think the judge is on your side, but you know, at the end of the day, the judge makes his own decision. He might agree with you there and then, but once he goes to his office, his chambers, and he decides, he deliberates, and he applies his mind to the matter, after hearing what the other party had to say, he might come with a different decision. Or he might come with something totally different that you did not even expect. Not even a win and lose. A middle way, which none of the parties expected. Therefore, it's important to focus, be invested in your case. Make sure you bring your point across to the other side with all supporting information or documentation if they are available. I hope you found this webinar useful, and I hope to see you online again soon. All the best for the legal matter.